Hello everyone and welcome to the channel, Ontario Law and the Older Person. So this is my second video involving advanced care planning, and this involves a board decision. So this will have some very grim detail. It's about an older person who is suffering from terrible health issues, painful, and it's a dispute over whether this person had already given instructions on how they would be treated or how they wanted to be treated in these circumstances. So again, it's a warning here. The details can get a bit grim. The information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decision should be made based on this material. Any viewer who needs legal advice should contact a lawyer. I'm going to go through some material that I covered in part 1 because people might not have watched part 1. It's good to be reminded what the statute tells us how we're supposed to behave when it comes to someone who needs decisions made on their behalf. So we're going to the statute, the Healthcare Consent Act, 1996. Section 1 gives us the purposes of the Act, which are A, to provide rules with respect to consent to treatment that apply consistently in all settings, and then B, to facilitate treatment, admission to care facilities, and personal assistant devices for persons lacking the capacity to make decisions about such matters. C, to enhance the autonomy of persons for whom treatment is proposed, persons for whom admission to a care facility is proposed, and persons who are to receive personal assistance services by, I'm skipping the top two there, they're not relevant to our discussion, down to the bottom, requiring that wishes with respect to treatment, admission to a care facility, or personal assistance services expressed by persons while capable and after attaining 16 years of age be adhered to. D, to promote communication and understanding between health practitioners and their patients or clients. E, to ensure a significant role for supportive family members when a person lacks the capacity to make a decision about a treatment, admission to a care facility, or a personal assistance service. And F, to permit intervention by the public guardian and trustee only as a last resort in decisions on behalf of incapable persons concerning treatment, admission to a care facility, or personal assistance services. That last bit, what that's telling us, if there is no one who is in a position to make decisions for someone else. So here we have a patient, they need someone to give consent to a treatment, they don't have any family or anyone else. Well, then the decision goes to the public guardian and trustee. And so you have a government representative making these very significant decisions without knowing the patient or anything about them, really. I'm dropping down to section 20, and this presents a list of people who can step in and make decisions for someone else, but I'm not going to go through each list word by item word by word, but people might be surprised about who can or cannot make this decision. So for example, if someone has a spouse, most people will assume, of course, the spouse would make the decision. But if you look at this list, spouse is not referred to until item 4. The first 3 items are people who have been chosen either by the patient when they had capacity or like a court or someone. So it's possible to have someone who's a substitute decision maker who is not the spouse. And the thing is, the healthcare providers have to first look for someone who has that paperwork or that court order. They can't just jump down to the spouse because the spouse happens to be there. And so I know I've referred to this in other videos. Is this practical? You know, this list that politicians put together, and we're expecting healthcare providers to go hunting out for people. So, and then you go further down the list and it's different kinds of relatives, including any relative of the incapable person. So that's on the bottom. Any other relative. So that could be anyone who is a blood relative. Let's say my cousin from Ireland is visiting me. They don't know anything about my wishes, but they can make a decision. There is not any indication of a friendship being enough to get you on this list. So something people have to keep in mind is, let's say your own family is toxic, you have left them and you have found family in the sense of friends who are your family for you. Well, that's not on the list. So if you have someone outside of your family, whom you would prefer to make decisions, you should make that choice and make that clear. So now I'm going back up a bit to section 5, where we talk about wishes. So wishes are, what kind of decisions do you want made on your behalf once you've lost capacity? So section 5, subsection 1, a person may, while capable, express wishes with respect to treatment, admission to a care facility, or a personal assistance service. So they basically are saying it needs to be while you still have the capacity to make these kinds of choices. Once you've lost capacity, if you haven't already expressed your wishes, we could have some problems there. Subsection 2, wishes may be expressed in a power of attorney, so like a power of attorney for personal care, in a form prescribed by the regulations. So has the regulations said it must be like this? Well, they haven't. In any other written form, orally, so spoken wishes, or in any other manner, which would cover, for example, sign language, stuff like that. Subsection 3, later wishes expressed while capable prevail over earlier wishes. So as I referred to in the earlier video, if you express your wishes in your 40s, but then in your 50s you have different wishes and you express those, then the later wishes prevail. However, this brings up an issue with written versus oral wishes. And again, as I mentioned in the last video, uh, a lot of people feel written content is what is binding, but oral content is not. So let's say in your 40s, you have written a power of attorney for personal care, it's in writing, but then in your 50s, you express different wishes, but orally. Well, we're going to have some difficulty there simply because people think written is real and binding where spoken is not. Then we look at principles for giving or refusing consent. So Section 21, subsection 1, a person who gives or refuses consent to a treatment on an incapable person's behalf shall do so in accordance with the following principles. 1. If the person knows of a wish applicable to the circumstances that the incapable person expressed while capable and after attaining 16 years of age, the person shall give or refuse consent in accordance with the wish. 2. If the person does not know of a wish applicable to the circumstances that the incapable person expressed while capable and after attaining 16 years of age, or if it is impossible to comply with the wish, so maybe the wish isn't founded on realistic expectations, like what is possible, what is not, the person shall act in the incapable person's best interests. Another brief look at best interests under subsection 2. In deciding what the incapable person's best interests are, the person who gives or refuses consent on his or her behalf shall take into consideration A. The values and beliefs that the person knows the incapable person held when capable and believes he or she would still act on if capable. And there's other stuff that's listed in this section, but I'm skipping over that. Just wanted to focus on A there. This is the last section I'm going to look at. Application for directions. Section 35, subsection 1. A substitute decision maker or a health practitioner who proposed a treatment may apply to the board, so that will be a tribunal, for directions if the incapable person expressed a wish with respect to the treatment. But, so we're still going to consider wishes expressed by a person when they have lacked capacity. So it's something to consider in the decision. Okay, but A, the wish is not clear. Maybe the person can't communicate what they're looking for. B, it is not clear whether the wish is applicable to the circumstances. So a person might have made a wish based on condition A, but they actually have condition B, and maybe the wish wouldn't apply. C, it is not clear whether the wish was expressed while the incapable person was capable, or D, it is not clear whether the wish was expressed after the incapable person attained 16 years of age. This is a case that involves some of these issues. It's called SG Re. It's from 2022. You can find it on the Canley website, and it is in front of the Consent and Capacity Board. And this is another reminder that we are going to be looking at some pretty tough details about the condition of this patient. So if you're at all disturbed by things like this, you might not want to see the rest of this video, but so there's your warning there. So this is my language. A doctor proposed a treatment plan that involved removing life support from a patient who was not benefiting from the intervention, who was suffering pain that would be getting worse over time, and who would likely die within 6 to 12 months. The doctor felt this plan was beneficial because it would end the patient's suffering sooner. The substitute decision makers, who were the patient's adult children, refused to consent to the plan. Their mother had expressed a number of times that one must do everything to sustain life, views deeply rooted in her religion. They believed that pain was inflicted by God to cleanse one's sins, and the patient would be rewarded for the pain she suffered in the afterlife. They also pointed out that the patient was aware enough to derive pleasure from visits with her family. The doctor applied to the board for an order as to whether the substitute decision makers were complying with the Health Care Consent Act. The panel found that the substitute decision makers weren't complying with the Health Care Consent Act, but went through its own evaluation of the patient's best interest and decided that life support should be continued. So this is the story behind why the panel made the decision that it did. Again, this is my language. I'm summarizing some of the text. On July 2nd, 2021, SG, 84 years of age, had a stroke and was taken to the hospital to the emergency room. Due to complications regarding her treatment, she ended up on mechanical ventilation and other equipment. She lacked the capacity to make her own treatment decisions. On August 29, 2021, Dr. Young met with two of SG's adult children, BR and SR, to tell them it was unlikely their mother would ever be able to breathe without a ventilator or leave the hospital. The doctor recommended the withdrawal of life-sustaining measures while engaging in pain management. By December 17, 2021, this proposal was provided via letter to the family. The family refused to give consent. Now, this is a bit of a gap in time going from August to December. So we can imagine that the person's health was deteriorating over that period of time, but it does seem like a big gap that the discussion was in August, but the letter was in December, but whatever. On December 30th, 2021, Young applied to the board to determine whether the SDMs, the substitute decision makers, were complying to the requirements under the Healthcare Consent Act. Here are some of the issues that were addressed in this case, and again, this is my summary of the material here. There was no dispute that the patient lacked capacity. She was capable of very minor interactions, responding to her name, shaking her head, or nodding in response to simple questions, and hand movement. Due to her, and I've tried to say this word so many times, tracheostomy, she couldn't speak, and no one knew if she would be able to anyway. But everyone agreed that she lacked the capacity to make decisions. So lacking in capacity doesn't mean no function at all. Just she can't make decisions in this situation. Another issue, whether the opinions the patient expressed before needing care could be considered wishes regarding her current circumstances. And then best interests. What are best interests? We have alleviation of pain versus God's plan and will. Here we also have a very significant issue, and it's something I've touched on in other videos. Here we have a person of a particular background, and she wasn't able to find someone who spoke in the same dialect she did. So again, me summarizing some of the content, the patient couldn't communicate in any way in English or French. The hospital did at times provide a translator, but he didn't use her dialect. She didn't respond to the translator's voice, and this was taken by the healthcare providers as a sign of the patient being unresponsive in general. One adult child acted as a translator as well as a substitute decision maker, but sometimes he misunderstood important terms and concepts. The translator wasn't present at family meetings. So how can they feel confident that she lacked capacity when there are these huge language barriers? This is a direct quote from the case, so not my wording. It is important to highlight a fundamental difference between a capable person making treatment decisions on his or her own behalf and a substitute decision maker making decisions on behalf of an incapable person. In the first instance, it is commonly known that a capable person has the right to make foolish decisions. This is an inviolable attribute of individual liberty and personal autonomy protected by our laws. Nobody has the right to interfere with a capable person's treatment decisions, whether or not those decisions are judged by others to be in the person's best interests. In other words, a capable person is the sole arbiter of his or her own best interests. And here I'm going to tie this in a little bit when it comes to older people. Um, I've mentioned this before. If a younger person, let's say, makes a bad financial choice, it's just brushed off as a bad financial choice. If an older person makes a bad financial choice, then that might be seen as the beginning of dementia because of this ageism involved. And the same thing is in healthcare. Some healthcare providers feel that any decision they disagree with is, in fact, a bad decision. So when we have that attitude combined with ageism, we can have a lot of problems. In contrast, a substitute decision maker does not have the right to make unwise or unreasonable decisions on behalf of an incapable person. A substitute decision maker must make correct decisions in accordance with the principles of consent set out in the Healthcare Consent Act, i.e., in accordance with the incapable person's prior capable wish applicable to the circumstances or the incapable person's best interests, judged objectively. This removes a fair amount of discretion on the part of the substitute decision maker to decide what is best for the incapable person. The substitute decision maker is not the sole arbiter of the incapable person's best interests. If the substitute decision maker strays from the Healthcare Consent Act principles, the board is empowered to intervene and compel the substitute decision maker to comply with those principles in accordance with the board's objective perception of the person's best interests as revealed by the evidence. These are the arguments of the doctor in support of the claim that they should stop treatment. So, again, this is me summarizing the text presented in the decision. It had been determined that there was no possibility of neurological recovery. SG would have to live in the ICU for the rest of her life. She had suffered multiple infections, and it was likely she would continue to do so. By the time of the hearing, SG had developed, and here we have a warning, some nasty details here. She had developed severe bed sores, deep enough to reach the bone, that were unlikely to heal, requiring painful cleaning and dressing at least once a day. Due to fluid retention, SG's limbs were severely swollen. With the combination of being constantly hooked up to machines, needing to be turned in her bed, her trach suctioned, wounds cleaned, and hygiene maintained, Young felt SG's life would be undignified and intolerable to SG. SG was experiencing a lot of pain. She would cry when her ulcer dressings were changed. However, given her inability to communicate, the nurses couldn't know exactly how much pain medication to provide to her, or when, so breakthrough pain was inevitable. There was no improvement expected, and increasing deterioration and pain were likely. These are the arguments presented by the substitute decision makers seeking to have the treatment continue. So again, I'm summarizing the text here. SG had clearly expressed her wishes in the past. SG's sister-in-law had been bedridden for 15 years due to a stroke and kidney failure. The sister-in-law's husband wanted to let her die a natural death, which was the panel's wording, but SG convinced him to take his wife to the hospital or God would hold him responsible for her death. So now I'm leaving the story, leaving the text. I'm just asking, what would do you think of that interference? Because I find it appalling. So she's trying to control someone else's life according to her wishes, not the wishes of the patient. So I would find that hypocritical. I find it very disturbing. Okay, moving on with the story. A brother-in-law had lost limbs in a rocket attack and later developed cancer. He wanted to die, but SG convinced him to get treatment, to never give up on life. When SG saw on the news images of people who had contracted COVID being put on ventilators, she told a witness she would want the same treatment. SG was an extremely devout Muslim who believed in the sanctity of life. Her children had consulted a spiritual leader who confirmed that SG's faith would require she be kept on life support as long as possible. So we have the panel's decision, and the question is, can it be said that SG had expressed wishes in the past? And the panel said no. So this is a direct quote. The panel determined that when SG expressed her wish to be put on a ventilator if she needed help to breathe, or when she referred to Islamic doctrine to preserve life at all costs, she was expressing a general wish or philosophy of life without any way of anticipating her eventual circumstances. SG's wish was not precise, clear, and specific to the medical condition she would develop. And what do you think of that? Uh, no one can predict exactly what's going to happen in the future. Like, there's no way. So, for example, if someone's putting together a power of attorney, for personal care, right? I want this other person to make decisions for me. Well, it's not like the document is going to say, oh, if I have cancer, this is what I want done. Or if I'm in a coma, this is what I want done. Like, it's just not how it operates. And so for me to bring this interpretation to the situation is problematic. And this is more directly from what the panelist wrote. SG did not know she would end up paralyzed in bed, fully dependent on mechanical ventilation for the rest of her life, unable to speak or swallow, with bed sores down to the bone, and no hope of recovery. She stated a wish, but it's a wish, right? When she had capacity, over the age of 16, upon seeing images of anonymous patients on a screen, with commentary in a language she did not understand, with no prior knowledge of what mechanical ventilation implies or requires, only her daughter interpreting the scene. Okay, they had a discussion. Why is this panelist assuming she doesn't understand what was involved with COVID patients getting treatment? I mean, this to me sounds very judgmental. Um, I don't understand how this panelist can just assume that as she didn't understand what was going on with COVID and the patients simply because her daughter was the one talking to her about it. Yeah, I don't like this panelist. Going on. At the time, she was healthy and could not have anticipated her current predicament, which is like almost anyone who's putting together a power of attorney. She did not have the benefit of being able to ask a physician or technician the risks and benefits of being on a ventilator indefinitely and the inevitable complications that would entail. Because SG had no way of foreseeing her severely deteriorated medical condition at the time she expressed her wish for life sustaining measures, the panel determined that her prior wish was not applicable to the circumstances in which she found herself in 2022. So, do you agree with that? I kind of don't. Another quote, the panel also determined that SG's devout adherence to Islamic doctrine did not rise to the level of a prior capable wish. To adopt that reasoning would be to remove agency and autonomy from a devotee of a particular faith. Even a person who is strictly and determinately religious should be allowed to stray from the tenets of their faith in exceptional circumstances. A person whose faith advocates for life sustaining measures may ultimately change their mind if they are in extreme pain, for instance, or feel they are a burden to their loved ones. Um, that last line kind of chilling to me. Do we really want to have people thinking, "Oh, I'm a burden to my loved ones. That's why we want to take me off ventilation." I just found that last little idea a bit creepy. So the next question is, given there were no express wishes, did the substitute decision makers act in SG's best interests? The panel said no. Again, I'm summarizing their content. While no one doubted that SG's children truly loved her and wanted what was best for her, best intentions were not enough. The Healthcare Consent Act made it clear that medical factors must be part of an evaluation of best interests. It appeared that BR sometimes disputed the evidence being presented to him about his mother's condition. He also made it clear that he would never change his position no matter what might change about his mother's condition. He told SG's physicians that he would consider treatment plans with his siblings and then get back to them, but often did not follow up with the physicians, which meant he wasn't adhering to the role expected of a substitute decision maker. The panel felt he never truly considered any options other than keeping his mother on life support. So, continuing with my summary of the content. Having decided the substitute decision makers hadn't decided according to the requirements of the Healthcare Consent Act, the panel made an evaluation of their own as to what the decision should be. Through their own reasoning, they agreed that SG should be kept on life support. So they threw out the idea of the patient having made given wishes before losing capacity, and they threw out the substitute decision maker's approach to best interests, but we're still getting the same result that the substitute decision makers wanted. The panel still didn't believe that SG had expressed binding wishes, but weighed SG's values and beliefs in the interpretation of benefits. Young was basing her understanding of benefits and best interests on pain, a loss of dignity, and a lack of meaningful engagement in life. To her, ending SG's suffering was the humane thing to do. SG's children believed that SG would derive a sense of dignity from the excellent care that she was being provided. She would not be suffering as she would be living according to God's will. She would be able to endure her pain because it was part of God's plan, and she would benefit from it in the afterlife. So here we have a situation with the doctor having a completely different idea about what is in someone's best interest, based possibly largely on what she was taught through medical school and what her cultural background is, as opposed to a very different cultural approach with this patient and this patient's children. This is my summary. In addition, she showed pleasure in her visits with her family. The panel felt this put her in a very different state than someone who was in a persistent vegetative state. The pleasure was an additional benefit to staying alive. And then this quote. The panel found the evidence inconclusive on whether the benefit SG was expected to obtain from the proposed treatment, ending of suffering, outweighed the risk of harm to her condition and well-being, certain death. The onus of proof lay with the Form G applicant, Dr. Young, to prove on a balance of probabilities that the benefit SG would gain from the proposed treatment outweighed the harm. The panel found that Dr. Young had not proven her case on the well-being part of the test. So page 29. So it's an interesting decision because they found that the patient had not clearly communicated wishes and that the substitute decision makers were not acting in her best interests in order, they wanted her to stay alive as long as possible because those were her values, but still came to the same result. And it's just an interesting thing to think about. Should a panel be able to even do this? Because they are not the physicians who were on the ground treating this person. They are not family members who know uh, the patient and would know what the patient actually values. Yet they're able to override the decisions of everybody else and impose their own. So, does that seem like a good system? I think there could be problems there. Anyway, so that's the end of this video. Thank you for getting to the end of this video. If you find this content interesting, it'd be great if you subscribe to the channel or left some comments, and have a great day.